Hello, and welcome everyone. And good morning, dear attendees who are joining in, I guess, at this time from the US. And thank you again being there, gracing our show, our webinar on DPDP Digital Personal Data Protection Act. Finally, after a lot of ups and downs and issues and stuff, finally, the Indian Data Protection Act has come into force. It's been a huge relief for everyone that finally things moved. So it was good for everyone. This act was basically there, being discussed and so many things happening for a long time. And finally, it came into being, and I'm glad that it happened actually. This thing is something that, will be of consequence to everyone interest in India and having some data being shared with India and stuff. So that's where it comes into place. And so let's just jump right into it. So the scope and the coverage. So primarily there will be an introduction to the DPDP Act and the scope and the coverage, what is covered and what is not covered, rights and principles of data processing and data fiduciaries, new terminology that was picked up in this, and then the regulation and the enforcement, and then of course the FAQs. So this will be in a string of many webinars that we'll be having on DPDP. And in case you're interested, you can head out to our website, infosec.com. Let me just type it out for you. Just head it out over there. So just head out over there and you'll see tons of information in our resource section under blogs and articles and stuff. So we are looking at adding many articles and of course having many more webinars on this. So this is just the beginning. If you attend the entire webinar, you are entitled to one CPE, continual professional education point, which you can use for various certifications such as CISA, CSSP, CRS, CSM and stuff. So, but you'll have to attend the entire webinar, because in case you don't, in case you do, and maybe ISACA writes to us or IC2 writes to us, so in that case we check the records, and in case you stayed around till the end, then you get the point. In case you bail out midway, then you don't. That's how it's going to be. And that's our YouTube channel. In case you haven't yet subscribed, and I'll really be surprised if you haven't, you can head out to our YouTube section, click on the subscribe button, and then on the bell icon so you get notified. We upload typically like one video a week. So that should be really a great issue from, say, PCI DSS, GDPR, ethical hacking, HIPAA, SOC 1, SOC 2, so many things that we work on. So this will really be helpful for you. So do head out over there. And as you go along, do type in your queries. Now, no one around has all the answers on DPDP. There's a lot of gray areas, and but I'll try and answer as much as possible during the webinar. But in case I'm not able to, then I'll definitely get back to you. In case you are uh, watching this webinar on YouTube, do put in your questions in the comment section, and I promise you I'll write back to you on that. All right. So, and as we end towards the end, you can always suggest a topic for the next webinar on various topics on compliance, regulatory standards, risk assessment, and stuff. So I look forward to hearing from you. And those of you who are not already been in touch with us, you should. And this is me, Narendra Sahu. I've been around for almost 3 decades now, out of which almost the past 2 decades has been with my company, VISTA InfoSec, and we do many things. Basically, on compliance, we don't sell any products or anything. And I'm myself a QPA, QSA, SSF, assessor, and CISSP, many things. Anyway, we are there across the world, whether it is Canada, US, Singapore, UK, Middle East, and we work on these things. I'll not take up your time introducing my company, because I know that you've come to hear the content, so I will not waste your time on this. So, and as we end the webinar, towards the end, there'll be a survey. Do drop in your valuable insights and comments. This really helps us. It could be negative, it could be positive. We spend a lot of time and money on these webinars, and I really hope this is of use to you. But your comments, even if critical, is very useful to you. Will be of very useful to us rather. All right. I hope you can hear me. If you can hear me, just drop me a message or something in chat. This is just to ensure that you are able to, I'm able to communicate with you in an effective manner. Do raise your hand or drop in a message in chat. I would really appreciate. Okay, yeah, thank you so much for the confirmation. The DPDP was introduced in the Lok Sabha on. Lok Sabha is the Indian, like the parliament types. And in August 3, 2023, it was passed on August 7, passed by the Rajya Sabha, which is like the higher bench, on August 9. It was notified in the Gazette on August 11 and became as a law as the DPDP Act 2023. Now it paves the way for personal data processing. Earlier to this, there was you can somebody can say the Indian IT Act and stuff, but that is actually useless. This thing will really be of great consequence to the industry, great consequence. And I'm not, exaggerating or in any manner. This will really be a great consequence. Everybody is hoping to see as to how this thing plays out. So there are 44 provisions, DPDP, and a schedule on penalties. So we'll get into this in detail. And then it is implemented in phases through separate notifications. And of course, there is an earlier erstwhile in the Indian IT Act, Information Technology Act 2000, there was, and then 2009. There was a section 43A which speaks about crime and how to handle it and stuff. So that was again extremely vague. And again, those tools will be omitted, will be discarded once this thing is in place and working. Then other data processing regulations as specified by various bodies such as the Reserve Bank of India or SEBI Stock Exchange would definitely be still in place and applicable. So let's move into then who and what is covered under the DPDP Act. Then there's the rights of individuals, that's what we'll be covering, and then the processing of data for children. We'll be looking into this going ahead. So who and what is covered by the DPDP Act? This is something which was one of the first questions that was asked. So the applicability and scope of the DPDP Act is covered under Clause 3 of the Act. Then under that, there are two sections. One is the material scope, the other is the territorial scope. Don't worry, we'll get into this in detail. But there are two parts to it, material and territorial. And then who is affected? There is the data fiduciaries, there is data processors, and of course, offshore businesses. Now, these are just the terminology. So you need to just remember the scope speaks of material scope, territorial scope, and then the who is affected speaks about data fiduciaries and data processors, and of course, offshore businesses. We'll get into the details, don't worry. Moving ahead, so the material scope, which is clause 3A of the Digital Data Privacy Act, Digital Personal Data Privacy Act. The material scope, it applies to all the personal data collected in digital form. Now, you should be underlining the word digital form, all right? So, because it excludes non-digital form. How it makes sense, I don't know. I don't think it does, but that's what it is. And personal data includes name, phone number, Aadhaar, and PAN. So, for those of you who are not aware, Aadhaar is like the SSN that is there in the US for individuals. PAN is also like the SSN. SSN in the US covers almost everything, but PAN is basically used by the income tax department and stuff. So, there are gray areas, there are a lot of overlaps between the two, but Aadhaar's coverage is a lot more expansive than the PAN. It only covers digital data, not offline records. It also does not cover non-personal data such as business insights or anonymized data, and even data processed for personal or domestic purposes. So for your own internal purposes, it's not really applicable, or data that has been made publicly available. Now, these clauses, I can think of so many issues in the way that these clauses could be interpreted. So please bear in mind that this is the first step that the country has taken towards data privacy. So it's a great step. And as time goes by, and I'm sure that there is something in the air that by March 2024 there would be a lot of amendments and clarifications coming up with regards to the act. So definitely it would be of great consequence. So by then, and maybe as the law matures, I'm sure that there will be a lot more clarifications coming in. As of now, quite a few things do not make sense. And as I said, the scope covers the material scope and now the territorial scope, which is Clause 3B of the DPDP Act. So the DPDP Act applies to outside of India only if it is related to offering goods or services to data principals located in India, not otherwise. So if the data is just lying over there somewhere, so really doesn't matter in that case. So only if it is for offering goods and services to data principals in India, then only it is applicable. But uh, let's assume I'm going to use the data to create a mess somewhere else. I guess that won't get covered. But as I said, as the time goes by, there is a lot of clarifications that is due to come, and I'm sure that would happen. Keeping my fingers crossed. Okay, so moving on. Now, who is affected? Who is affected by this? This is something. which will be of consequence to everyone as to who is affected by this. Now, who is affected? The data fiduciaries. So these are something called as, so there is change of terminology. So in GDPR, as you know, there is something called as data controllers and data processors. So this is just another word for the data controllers. So these business define the purpose and the means for processing. Same thing as in GDPR, they define as to what is being collected, or rather why it is being collected, what can be done with it. So they make the decisions about the user's data, and they decide the need, usage, and retention of the data. And they are responsible and accountable for the data under the law, which is GDPR, right? And sorry, DPDP. So the definitions remain the same. So I understand it sounds a bit odd, but yeah. Then the next point would be about data. So these are businesses which is like one line below your data fiduciaries, or in brackets data controllers. So these businesses process data for the fiduciaries, and they have to do some whatever the fiduciaries or the controllers instruct them on what to do. They have to do it, and they are not really responsible, because it's primarily speaking the fiduciaries or the controllers' responsibility to define what can be collected and what can be done with the data. And examples include your cloud and KYC service providers. They take the data, they process it, and they use it as per the requirements. So who's affected? That becomes a point. Who gets affected by this? So all the offshore businesses, if you offer goods or services in India, then the law applies to you. So most of our clients are outside of India. So that's when the DPDP was launched. That's what was asked to me. Does it apply to us? Yes. If you're offering goods and services in India, then they do apply to you, whether you're hardware or a software vendor or whatever be the case. And if you are there, then the data, if you are collecting the data for whichever reason for providing goods and services in India, then of course the law matters to you. So which are the rights of the data principals? So the data principal would be somebody like, who's a data principal? I guess you can guess who's the data principal. So data principal would be people like you and me, who are the end people whose data is covered under what is called as privacy. So Act 12 speaks about correction or erasure. So data principals can ask their data fiduciaries to correct or erase their personal data. Now there are the checks and balances in GDPR. It is extremely clear. So unless there is a need for it, the fiduciaries cannot say no. For example, if I'm I'm a telecom, say Vodafone. You are one of the users of the telecom of my enterprise, and you can't call me and tell me that erase all my call records, because the rule of the law speaks that the data call records needs to be preserved for a period of 5 years, 7 years, 10 years, depending. So these people, you can't just call them and say that to you, or you cannot say you take a loan from a bank and then call the bank and tell them, okay, erase my loan records, because that's my person. So those things cannot be done, right? It sounds funny. Yeah, it is funny. So, but had they not put the checks and balances, then there will be people actually doing that thing. So nomination clause is there, which is clause 14.1, if I can call it, in DPDP. Basically, it is the data principals have the right to nominate any individual to exercise rights on their behalf in the event of the death or any sort of incapacitation, means they are rendered incapable in some way. And then grievance redressal, which comes under clause 8, article 10 of DPDP. So this basically says that data fiduciaries must offer readily available grievance redressable mechanisms to data principals. So there should be some sort of a clear chain of command of communication between the data fiduciaries and the data principals, which enables the data principals to contact the data fiduciaries and exercise their rights. And the next part is the right to obtain information. Now, what sort of information is information about processing? Means if you're processing my data, then what data you're processing? So data principals have the right to to access information for processing about the personal data. Means where on earth are you going to use my data? They have the right to demand that from the fiduciaries. Okay, then the responsibilities of data principals, which comes under clause 15B to C and E of the DPDP Act. The number one thing is not to impersonate. So I cannot ask for the data on somebody else's behalf and say I am that other person. The impersonation, suppressing information and applying for any document of proof from the state. So I need some, maybe my credit rating. So You cannot claim that in my name. So those things is called as the non-impersonation, which is fairly, obvious actually. Provide authentic information. That is, the data principals should endeavor and show that they have done enough to provide authentic information and as much updated information as possible to the data principals when asked. And then not to register false complaints, which is covered under 15D clause. So it basically means not to register false or frivolous grievances or complaint with a data fiduciary or the board. So no lodging of false complaint. This is again, it seems like a no-brainer, but it's very, very important because many a time we see that the law is skewed in a particular direction and there's 100% bias to a particular side of the story. So, for example, we look at the Tenancy Act. So, in that case, the majority of the tilt is towards the tenants. Or if you're talking about, no, I don't want to get into political discussions now. So, one was the tenants part, or if you're looking at the labor law. So, the labor law speaks very highly about protecting the rights of the employees. But what about the rights of the employers who have given the employment to the employees? So those things are there. So not to register false complaint clause is extremely valuable in my opinion and very needed to be done to dissuade people from harassing genuine parties for maybe they didn't write the way that somebody spoke to them types. So for such immaturity, it's very important to have a this clause as not to register a false complaint. Otherwise, it will be considered as a misrepresentation from you. Now, what about processing of data for children, which is clause 9 of the data DP of the DPDP? So it speaks about if the data is a minor, if the data principal is a minor, if the user is a minor, then parental consent is mandated and prohibited is taking the information just by the child saying yes to you types. But there are sometimes, exceptions are there. That is rules framed under DPDP A 2023. So there are certain classes of data fiduciaries or purposes of processing data which may be exempted. And of course, exemption by the central government. So the central government might also grant exemptions if processing is done by verifiably in a verifiably safe manner. But these are, if I can see this, basically cover-ups for hiding any screw-ups by the government. Because what do you mean? Is somebody can show that they are reasonably in a reasonably safe manner processing the like a power plant provider or somebody who's providing power in the city. He can say that okay, they are processing the data in a safe manner. Will it be fine for them to give out that information to say to their bank? They're also having a bank in place or a funding organization in place, and then use that data for selling their other products and services. So all these things are there. I personally speaking, I don't agree with such exemptions because the law is a law. It has to be bloody followed by everyone. Cannot be that the central government can maybe even make them their own self excluded, which was happening in the earlier version, which got rejected by the parliament. So the government themselves making themselves an exception to the rule is not really a good trend. So for data processing, there are a few things. One is the consent, as the consent is very, very important, which has to be a primary basis for data processing. And why they are processing whatever they are processing, which is the grounds of processing data. And then, of course, the cross-border data transfer. So these are the three different angles in which this can move ahead. And now let us look at each of those points, which is let's start off with consent as a primary basis for data processing. It is covered under clause 6.1 of DPDP Act. So it says that consent must be free, it should be specific, it should be informed, it should be unconditional, and of course unambiguous. So these are the five key requirements for any sort of consent which might be required. So when you're talking about consent as a primary basis for data processing, the number one thing is that the data principals, means end users who gave the data, have the right to withdraw their consent also. Now, if the consent is withdrawn, the data processing must cease immediately unless it is authorized by the law. So, as I gave an example, say of a police, or say of a bank, or say of an electricity service provider. So in that case, you can't ask them to remove my data. They can't do that. Then the next is user can access information in English or any other language listed in the eighth schedule of the Indian Constitution. Increase the coverage of DPDP Act within their own within the company as well. So, what could be the grounds for processing data? This is something which is pretty straightforward, actually. Nothing great about it, types. So, data. So, there will be the legitimate uses. 1 minute. It should be non-consent based. Processing is now called legitimate uses, and both the fair and reasonable purposes and the public interest grounds have been removed. Now, what do I mean by that? So, for example, there is an ex which is a pregnant woman. She enrolls herself on an app or a prominent website so that they can avail of the government's maternity benefits program. And while consenting to providing her personal data for the purpose of availing of such benefits, government may process the personal data of ex processing to determine their eligibility to receive any other prescribed benefits from the government. So those things defines the legitimacy, and then processing without consent, which is clause 678. So the data fiduciaries, which means the data controllers, can process data without consent when the data is voluntarily provided. Now, this really, I don't, this sounds really bad, yeah. I don't know. So, if they have given it voluntarily, then you can do whatever you want to do. So, this allows processing without consent when the data is exchanged for a service. So, you can say that, okay, you put in your family details and you get a nice burger in return for free. So, that could be, when the data is exchanged without a service, or in case of say for example, as the example is given, sharing phone numbers with a pharmacy for a receipt for providing data for rental accommodation services. So in that case, they have agreed to it and they're going ahead with it. Nowadays, as you know, nobody even reads that screen which comes to the help file. So only God can help us on this, I guess. So the grounds for processing data, it could be state functions, it could be in relation to employees or assisting in health emergencies, or maybe some other case is getting filed somewhere. So, and then again, providing, issuing benefits, and then sovereignty and integrity and security of the state that cannot ever be underestimated. So, they have some suspected terrorists sitting somewhere. They have the right to go through any sort of privacy, you know, concerns anywhere and get the data out. Now, this could be a consequence to my dear clients in the US and other places. What about cross-border data transfer? So, this is something again that he is working on, and maybe in the next 6 months or so, there could be some more amendments released and more clarity being given. So this is the central government trying to limit the transfer of personal data beyond India. So local storage, you must have seen that act, something on those lines. So existing Indian laws provide higher protection or restriction on the transfer of personal data outside India. Those will still apply. Now, stricter sectoral data transfer restrictions such as RBI payments, data localization, all those things will still remain. You'll still need to do it. Then what about the data fiduciaries? What are their responsibilities? And how do you check the compliance of businesses under DPDP? So let's jump into it directly. Data fiduciaries, this is the controller. So this will be the most painful and of course the most rewarding part of the job. So it speaks about completeness, accuracy, and consistency. So many times people use this intermittently, which is not the case. It speaks about the data fiduciaries must ensure personal data is complete, accurate, and consistent. That is with regards to completeness and accuracy. Now, technical and organizational measures, which comes under the next clause, under clause 8, is that the DPDP Act. And then reasonable security safeguards, clause 8.5 of the DPDP Act. Then reporting personal data breaches. Now, again, even certain computer emergency response in India, even they had done some very good documentation on BCP testing and all. And the next is the deletion of personal data. As soon as your work is done, you have to retain evidence that whatever data is getting discarded, then there are some records of that kept somewhere, and it is known that this data has been stored somewhere. And then, of course, the grievance redressal mechanism. So the data fiduciaries must establish a mechanism for grievance redressal of data principles. All right. So now we are hitting the road more tougher now, and I really need to wrap it up soon. So stay with me on this. Okay, we'll be fast, precise, and deadly. All right. So appointing a data protection officer, clause 11.1. So an individual who is based in India shall be responsible to the board of directors for such similar governing body of the data fiduciary and who shall act as a point of contact for the grievance redressal mechanism under the DPDP Act. The same thing we are doing it we are doing it for a few of our clients based in the UK and US. Now, appointing an independent data auditor, which is also required. Now, this thing is to carry out the data audits. We shall ensure the compliance of the significant data fiduciary with the provisions of the DPDP Act. Then, undertaking periodic data protection impact assessment (DPIAs). So, and last is other obligations, which is under clause 10(2) and so many other things. But what I would suggest to my listeners is that ensure that as a controller, maximum of the responsibilities falls on you. So stay awake over here. And again, until more clarity comes, in case there is an issue, you will be really be caught, unawares in that case. Okay, compliance for companies and businesses under DPDPA. So how do you go about for the compliance? Must very much important is to develop and train personnel in a standard operating procedure. Next is cooperate with the data protection officer who's there internal to your organization. By the way, you can even outsource it. It's not necessary that you need to hire at all times. Then implement a consent management mechanism. That how are you going to capture the consent of your users or of your data principals? Then conduct the data protection assessments. Then maintain valid contracts with the data processors. See, understand, in case there is a breach, God forbid, with one of your data processors, you will be taken to task. You can't say I had outsourced it to that other guy and that other guy was an ass. You can't say that, right? So because finally the accountability and responsibility remains with you. That doesn't get outsourced under any circumstance. Then map data interactions and identify teams and functions for who's going to do what. Then revise the interface to display pop-up notices for the privacy policies or whatever. Then update the privacy policies as it's required in case you don't already have one. Make one in case you don't already have one. Then review the vendor arrangements, which could be the vendor contracts, and then train all the employees in all the departments. And last, as you rest, appoint officers such as a grievance officer. This is very important. It need not be a full-time job, but you really need to have that in place. So let us move into the regulation and enforcement part. So you need to have a data protection. There will be a data protection board of India, which is not really there at this time. So appeals against the decision of the data protection board. That is again, we are working on it. What are the penalties? It is there. It speaks about some 200 crores or something, which is, if I do the maths, 50 crore, $50 million approximately. And then there are exemptions to that also, as we had seen earlier, which literally, if I can say that, weakens the law. So what about the data protection board? Say it was established under Chapter 5 of the DPDP Act and consists of a chairman and other members, and it acts as an executory, means more like a middle person who is watching and can do some, management of the people under this various headings. It could be foreign companies, it could be data controllers or fiduciaries, data processors. But this body will be controlled by the central government and exercises all the powers and functions laid down in Section 27 and 28 of the DPDP Act. It's not a very big law, my friend. It's very easy to read and stuff. So, in case you want, you can always go through it. Then act as a civil court with original jurisdiction for act-related complaints or matters. So this is again a very welcome thing, because as you know, there are millions of cases pending before the courts. Without this adding to it, they can definitely do better. So the data protection board of itself acts as a civil court. This will really be a great boon for the companies in India. Then Section 39 bars civil courts from entertaining related suits for processing. So you can't go to a civil court. In short, you have to go to the data protection board. Now this is still being formed, ladies and gentlemen, but I'm sure that it'll be in place soon. There's a lot more amendments and wisdom as to how this can be done. So appeals against the decisions of the Data Protection Board (DPP), as per orders passed by the TDSAT, they are appealable before the Supreme Court. So even if you're not happy with it, you can still go to the Supreme Court. So and the next thing is that you have to do it within 60 days. And in case you are still not happy with the board, you can definitely go to lodge a complaint, formal written complaint against the TDSAT. Okay, now what are the exemptions in that case? This becomes very important to understand as to what are the exemptions against this. So certain obligations are by everyone, data fiduciaries or rights of data principals. We logged in to just help you, but otherwise, this will be a great help for everybody. Exemptions are there, which include prevention, investigation, or prosecution of offenses, then enforcement of legal rights or claims, then processing outside of India, which is also a major thing, and then ascertaining the financial information. And so, the processing of personal data for research is exempted from the DPDP Act. Archiving or statistical purposes. This is exempted by the Act. So, what is defined by research and what could be the boundaries of such a research and outcome, to whom can it be preserved, and what sort of activities can be done under this personal data for research is really not very well clarified. But I'm sure that going ahead, that might come into place. And so again, whatever the this thing is, please understand the Data Protection Board heads the DPDP. You can appeal against the DP the decision of Data Protection Board with the TDSAT. And then if you're not happy with that, you can always approach the Supreme Court, which is as per Section 18 of the TRAI Act. Then what are the penalties for non-compliance? This is really steep now. So it depends on the nature and the gravity and the duration of the breach and the type of the personal data affected. Then how long it's been happening, or has it repeated after the last breach, which shows really incompetence. Then gain or avoidance of loss as a result of the breach. Then the effectiveness of any mitigation measure action taken. So that's where I say to everyone that do not just implement something for the heck of it, because you might need to prove on what basis you took this call for implementing a particular control. And then the proportionality and the effectiveness in deterring future breaches. So this is how they will be judging as to how much will be the punch that you'll have to take. And then, of course, the impact of the penalty on the person responsible. So let's assume if it is a penalty of, say, 10 million. So a small size company will be wiped out $10 million. But if it is something like some of the largest, like the business houses in India, Ambani and Adani and all, to them, if they get a $10 million penalty, it is not even peanut. Then the maximum penalties for various violations include, they've given what sort of breach of provision is there and what could be the punches that you'll have to roll with, right? So this thing, breach in observing the obligation of fiduciary to take responsible security safeguards to prevent personal data breach, literally may exceed to 250 crores. And then again, a breach in observing the obligation to give the right, the board or affected data principal of a personal data breach, this can again go up to 200 crores. So 1 crore, if you ask me, is 10 million, right? So 250 crores is 2,500 million, means 2.5 billion Indian rupees. If you want to convert that into dollars, you might want to divide it by whichever is the current dollar rate, which is like 80 rupees, 83 or something in India. Anyway, few quick questions. Will the DPDP change the way companies collect personal data? Yes, it will. So under the new law, fiduciaries must either obtain an individual's consent or ensuring that the collection and the processing falls within the certain legitimate uses as recognized by the law. So it is always in the best interest to just take the consent. So then another point is, there are tons and tons of personal data already lying outside. I mean, before this act even came into place, would it apply retrospectively? That's the question. So for such data, they are required to send individuals a renewed notice. So maybe the bank who has my data, they need to send a renewed notice to me that outlines what is being processed, why it is being processed, and the procedure for exercising the rights. All these comes under Clause 7 of the DPDP Act. So, can companies transfer or process data outside of India? Yes, of course you can. It's a free trade. But the Indian government can restrict transfers to certain countries through notification. So maybe the Indian government might say that, okay, don't send particular data to Pakistan or this type of data to say China. So stuff like that might happen. There is no definitiveness as of now. Now, what will happen if somebody didn't want to comply? So in that case, again, there is nothing that they have to fill up a form and give every year. As of now, at least from what I know. But in case it does fly, penalties will be very, very severe because it will be as if, as per the Income Tax Act, you're supposed to be filing a return, an income tax return. Now, in case you don't, the IRS or the wing, the revenue management wing of the government will really come down, very hard on you. So, what is the time limit for compliance with the law? How often and how soon? So there is again no time limit, and implementation of certain requirements may occur before others through a graded implementation. So in this thing, what I would suggest to you, my friends, is that do an analysis to come to know where are the weaknesses and have a very strong risk treatment plan as to if you're differing something, for what you're differing, and when you intend to finish it anyway. How can we help you? Of course, we can help you by doing all these. So we are into all these consulting in privacy and all the GDPR, HIPAA, you know, PDPA, PDPB, so many PPIs, there's so many acts are there. So we even work with the DPDP Act, much more things that we work on. And this is like a brief about our YouTube page. There are thousands of subscribers for now, and that's our LinkedIn panel, and that's our contact details. So do drop us a line in case you think that we can be of some service to you. Do not forget, as we go ahead, to fill up the survey and provide your valuable feedback. I, it seems like a brave new world. I do understand, but there is a lot of clarity that is still not in place. So it's not that I have not covered. It's basically it is not there. So as the government releases amendments and clarity, we'll be issuing statements, we'll be issuing articles, and of course videos for your consumption to come to know how things are rolling. All right. So and do provide your feedback as you are going ahead. So thank you again very much for sharing your valuable time. And if there is something that we can do for you, please do drop in a line. Until then, have a great day ahead. Take care. Bye bye.